I'll tell you one thing. You know, in law, there's something that says if you got the law, argue the law. If you've got the facts, argue the facts. And if you don't have neither one, argue how you feel. And that's basically what the JIC has done, and the SPLC, the Southern Poverty Law Center, whose business is right around the corner here. They're the ones that hired the prosecutor. They're the ones that brought the case for the second time. They don't want anybody opposing any agenda of the homosexual movement. That's what they don't want. But this opposition, if it were opposition, it's not. It's a legal order. You've been handed two documents. One is the legal administrative order issued on January 6, 2016. The other is an affidavit that I made regarding the confusion that exists because the Supreme Court of Alabama would not rule. There are clear law in this case. They said that I urged the federal courts or the probate judges to disobey the federal courts. As Matt Staver said, there is nothing in any of that administrative order that says that. Nothing. In fact, I said I'm not at liberty to give you guidance. That's the Alabama Supreme Court that gives you guidance. Furthermore, I addressed the confusion that was caused by the delay in this court's ruling. And I said until the Alabama Supreme Court rules, this order remains in full force and effect. That is law. United States Supreme Court versus mine workers, in the mine workers case, in 1947 said if an order is given, even if it's unconstitutionally based, if you have subject matter of the jurisdiction in person, that order remains in effect until it is reversed by orderly and proper proceedings. Until the Alabama Supreme Court made that decision, there were no such proceedings. And when they did make that proceeding, that order, on March 4th, they left the injunctions in effect. Under Alabama law and the United States Supreme Court law, those injunctions are in effect, and probate judges could be held in contempt. So it's the objective of my January 6th order to get the Supreme Court to rule on this case. It was their decision. I said I can't give the probate judges any guidance on this matter. I'm not at liberty to do that. And what the Supreme Court decides, the Supreme Court decides. They say I tried to influence the Supreme Court decision. I told them, it's your decision to retreat from Obergefell or take the other position and agree with Obergefell. It was the Alabama Supreme Court's decision. They did rule and they left the injunctions in place. This is strictly about a legal order. It's not about how I feel. It's not about pushing. I have a duty as Chief Justice to take affirmative and corrective action, appropriate action, affirmative and appropriate action to correct or alleviate any condition or situation adversely affecting the administration of justice in this state. This is the first time that the JIC has ever come against a Chief Justice administrative order. It's the first time that the prosecution was the same person who once was the legal director of the SPLC who brought the charges against me, not only in 2003, but later today, in this case. We expect that the JIC will face up to the fact that they do take joy in this.
Right.
And we expect the COJ to enter a case giving a summary judgment in this case because there's no evidence that we have violated any law. It's a legal order. You have the administrative order in your possession and the affidavit. Read them. Those memoranda were issued long before I issued a January 6th order, in which I said, as Chief Justice, I have the responsibility to ensure that our court rules in accordance with the canons of judicial ethics, which require a decision to be made. And that presumptive time period is 6 months. It was over 8 months before the decision was made. I tried to stop what eventually occurred. I thank you very much for coming today. I hope that you have a safe journey back home and appreciate you being here. Thank you.